everyone, and welcome to Thorough Newspaper Analysis, which is presented to you by LawSeco. So today we will be analyzing the newspapers for both the 2nd and 3rd April, which means for yesterday and today both. So that is why we have 3 articles on the plate today. 2 articles are from yesterday's newspapers, which is the first one is an act of colourable legislation from the Indian Express. This article basically talks about as to what do we mean by colourable legislation and how there have been instances of colourable legislation. And the second article from yesterday's newspaper is again from the Indian Express, which is titled as A Health Warning on Land. This article talks about the new Digital India program that has been introduced in the land records as well, and what are the difficulties that we might be facing in this particular area, and what are the benefits of this particular digitization of the land records. And then the third article, which is there from today's The Indian Express, is titled as Unreasonable Restrictions. So this article basically talks about the Right to Education Act and what are the limitations and restrictions that have been imposed on this particular act, due to which it has not been able to expand the way it was intended to. And finally, we have the News and Flash column. So before we move further, let's have a look at the Project Maverick, which is the CLAT prep course from LawSeco. So this is almost a free CLAT course because it costs only ₹100 to your pocket. So if in case you're preparing for CLAT 2021 or 2022, you can definitely enroll yourself in this particular course. You can find the link to this course in the description box below. With this, let's see what is the multiple choice question for the day. 9th Heart of Asia Istanbul process has recently been held in. Your options are Dushanbe, Delhi, Istanbul, or Kabul. You can put down your answers in the comment section below. This is the descriptive question for the day. What is Digital India Land Records Modernization Program? Is it able to address different challenges regarding management of land records in India? With this, let's start our first discussion from yesterday's newspaper, which talks about the Places of Worship Act 1991 and why has it been challenged in the Supreme Court. Though we've already done this article in our previous sessions, but since it was reiterated and is of good importance for our exam as well, and if at all we want to develop our general awareness too, so let's understand about this issue once again. So the Supreme Court recently issued notices in the matter of a PIL challenging sections 3 and 4 of the 1991 Act to be unconstitutional, void ab initio, and against the basic structure of the Constitution. Now here, let's understand that what do we mean by unconstitutional, void ab initio, and against the basic structure of the Constitution. So by the meaning of unconstitutional, we simply mean that something that is against the vibe or something that is against the essence of the Constitution of India. So that would be considered as unconstitutional. Now, when we talk about something being void ab initio, it simply means to be invalid from the very beginning. The name itself is stating void, which means invalid, ab, that is from, and initio is the beginning. So something that is invalid from the very inception or from the very beginning of a particular thing is considered to be as void ab initio. And it is also being considered to be against the basic structure of the Constitution. So it was in the year 1973 that via the means of Keshavananda Bharati versus State of Kerala case, the doctrine of basic structure was propounded. So this doctrine of basic structure basically proposes that the parliament can amend the Constitution and even the fundamental rights can be amended, but the basic structure of the Constitution cannot be destroyed. Now, if we say that what is actually the basic structure, there are generally 20 to 22 items or tenets which are a part of the basic structure. So these are the things that form the basic essence of the Constitution. For example, the federal structure of our country, the parliamentary system, judicial review, right to equality, Article 32. Then we have various powers of Supreme Court, High Court, the supremacy of Constitution, independent judiciary, etc. So all of these points are a few of the all points that form the basic structure of the Constitution. With this, let's understand firstly as to what are these relevant sections, and then we will understand as to why are these arguments coming up against this 1991 Act. So section 4 clause 1 of this particular act declares that religious character of a place of worship existing on 15th August 1947 shall continue to be the same as it existed on that date, which means that, for example, if there was a building which was considered to be a temple on this particular date of 15th August 1947, so it shall be considered to be a temple whatsoever in the coming years as well. And then Section 5 provides that the Act shall not apply to any suit, appeal, other proceedings related to the said place or place of worship, that is Ram Janmabhoomi or Babri Masjid. So basically, this kinds of draws a kind of a delineation or a demarcation which is not really justified. And here are the arguments that are presented against the 1991 Act. Firstly, the argument says that it is ultra vires the Article 32 of the Constitution. So basically, it says that it actually violates Article 32 of the Constitution, which bars the jurisdiction of the Supreme Court. Now, under Article 32, it is said that if at all a fundamental right of an individual is violated or abridged or taken away, that person can directly move the Supreme Court. So here, keeping the Supreme Court also out of the ambit of bringing any suit or appeal in this particular case, Article 32, which is considered to be as the heart and soul of the Constitution of India by Dr. B.R. Ambedkar, is being abridged. Then the second point is that it weakens the preamble, which provides for secularism, and thus it brings in Article 25 and 26, which are the freedom of religion and ultimately are the fundamental rights in themselves. And as these articles provides the liberty of faith, and the preamble itself provides liberty of faith, belief and worship, so this particular thing is being limited by means of this particular 1991 Act. And thirdly, the intent behind the 1991 Act is that it identifies the need and importance of such resolutions, and exclusion of Mathura and Varanasi dispute is unacceptable and arbitrary. That is why such classification is not seeming out to be reasonable enough, and thus this exclusion is very much arbitrary and unacceptable. With this, let's discuss the second article for the day, which talks about the land records and that how digitizing or bringing the entire land record system in a digitalized system would be very much beneficial. And thus, the government has introduced the Digital India Land Records Modernization Program, which in short is known to be as DILRMP. So I'll repeat it once again. It is Digital India Land Records Modernization Program, basically to achieve the goal of updated and conclusive land titles. Now, as we know that where in India, the Digital India program is running through, and we want to decrease the rural-urban divide which is there in terms of digital area. So here it is important that the land records, they are also digitized so that the frauds can be checked in, and also the ownership or the title of any particular land can be established easily and without looking into such hefty and exhaustive records or land records which are available in the physical hard copy world. So here, let's understand first that what does this program, this is with Digital India Land Records Modernization Program, provide for in basics. Firstly, it provides a common framework for reporting the progress of land record management by states and union territories. So here, all the states and union territories at one single portal can report all of this common framework, and the land record and can be managed and can be maintained at one particular area. Secondly, it has launched the NCAER Land Records and Services Index in 2020. Then if we talk about this particular thing, which is the NLRSI, which I just discussed, which is the NCAER Land Records and Services Index. So this basically assesses states' performance on two broad dimensions. Now, what are these two broad dimensions? Firstly, the level of digitalization, and secondly, the quality of land records that are maintained. And it takes into consideration the extent of integration between registration and textual records. As to, for example, 100 plots were registered in a particular state, but only the textual record or the records in complete textual format was provided only, let's say, for 70 plots. So here, these 30 plots, which were, though they were bought in a particular area, but they were not registered, or they were registered, but the records were not maintained, are very much liable to various kinds of frauds. And that is why this particular platform, which is NLRSI, takes into consideration the extent as to how much is their integration between the registration and as well as the textual records. Then the swiftness of process of updating ownership as the result of registration of a transaction. For example, if person A sells his land to person B, so definitely the title and ownership of this land will move and it will be shifted towards person B. So how swiftly this particular record or this particular transaction can be recorded is also monitored under this particular initiative. With this, let's understand that what are the issues that are attached in the Indian land records. Firstly, the dismal state of land records. Now, this is the most major issue that is there, that the situation of the land records, the prevailing in the current situation, is very dismal and it's very dingy. Now, the reasons behind this is firstly, the failure of Indian administration to evolve from British era land policies. So we still, in some other way, are stuck in those British era land policies which used to prevail like 100 or 150 or 200 years ago, and due to which we have not been able to modernize the land record system. Secondly, variation in land record regulations and policies from state to state, due to which it is not practically possible in such scenario to bring a consensus of all the states due to different laws and different regulations which are there from one state to another. Thirdly, lack of skilled manpower in land record departments in states. So that is why specialization and more of creativity and specialization is not being able to be achieved in this particular area due to lack of the skilled manpower. Fourthly, weak linkages between the revenue department and the survey and settlement department. Because see, particular revenue for a particular land or tax goes to the revenue department, but then we have different departments for maintaining the survey and settlement of those land records. So that is why there has to be good integration and cooperation amongst various departments of the government in order to make a coherent data record of these land transactions. And fifthly, inherent structural rigidities. So that is why we need to digitalize the system, and we also need to work with these drawbacks and these limitations that we currently have in the Indian land record system. With this, finally, let's discuss the third article, which is there from today's Indian Express, which talks about re-examining the Right to Education Act. So as per the author of this particular article, the Right to Education Act is biased against the private non-minority institutions. So as we know that the minority institutions do not really have this compulsion of providing these particular seats under the RTE, but the other, which are non-minority educational institutions and that are private in nature. So it is said that the RTE, which is Right to Education Act, is way more harsh and it is a bit against these private non-minority institutions. So if we try to understand the right to education as a fundamental right, so initially this was not a fundamental right and it was mentioned and enumerated under Article 45, which was a directive principle of state policy, and it provided that the state should provide free and compulsory education to children up to the age of 14 within a decade. And finally, when by the means of the RTE Act, this particular aim of the state was achieved, so it was moved from the directive principle of state policy and was made a fundamental right under Article 21A. Then, in 1992, in the case, the Supreme Court, in the case of Mohini Jain versus State of Karnataka, held that right to education is a part of right to life under Article 21 of the Constitution. And then, in 1993, the Supreme Court in Unni Krishnan JP versus State of Andhra Pradesh said that the state had a duty bound. It was actually duty bound to provide education to children up to the age of 14 years within its economic capacity. And thus, private and minority institutions would have to play a role alongside government schools. So in 2002, it was included in Article 21A of the Constitution. So if we talk about the reservations in the private institutions, so basically it is said that the minority schools, we'll discuss about it as well, because here in some situations, some minority schools and institutions have to provide the reservation to the children or seats to these children under the RTE Act, but not all. So let's see. In the case of PA Inamdar, it was held that there shall be no reservation in private institutions and that minority and non-minority institutions would not be treated differently. So here is a chronology and we need to understand. So that firstly, in the PA Inamdar case, it was held that there shall be no reservation in private institutions and that minority and non-minority institutions would be not treated differently and they will be at par. But in 2005, the 93rd Constitutional Amendment Act added Clause 5 in Article 15, which overruled the Inamdar case and permitted state to provide admission even in private institutions. So firstly, they were not even allowed in private institutions. And then after the amendment to 93rd Constitutional Amendment, such reservation was allowed in the private institutions. Then the RTE Act provided for 25% reservation in private institutions, which was upheld by the Supreme Court in unaided private schools of Rajasthan versus Union of India, but the court exempted only unaided minority schools from it. So that is why here it cannot be said that as a blanket thing that the minority institutions do not have any binding thing from the RTE Act, but there are some other exemptions and there are some other regulations which need to be taken care of. And then the Supreme Court in Pramati Educational Trust case held that both aided and unaided minority schools were exempted. So that is why there are some different contentions regarding this, and that is why some minority institutions are needed to provide such reservations, but some are exempted from it. So with this, let's see what do we have for news and flash today. Dadasaheb Phalke Award has been awarded to Rajinikanth. So for his contribution as an actor, producer, and screenwriter. So if we talk about this particular award, it was instituted in 1969 and is the highest honor for an artist in the Indian cinema. And if we talk about Rajinikanth, so after his early life as a bus conductor in Karnataka, he joined films at 25 age. His first big commercial hit came with his 25th outing. Secondly, the World Cities Cultural Forum. So, Chief Minister of Delhi Arvind Kejriwal will represent Delhi and India at the forum, which comprises of 40 world cities, including London, Tokyo, and New York. And the theme for the year 2021 is the future of culture. So we're done for the day. We hope it was a good and informative session for you all. Thank you so much for staying tuned with LawSikho, and you may subscribe to the channel for such more updates to come.